sitting in the back side may kindly come to the front row as there are seats vacant. Kindly. Second. Good evening to all. We are at the second lecture in the fourth session of the Continuing Legal Education Program 2022, and as you all know, this is a continuation of the last session, and without much ado, I invite the star of the evening, Advocate Sasthamangalam Ajith Kumar sir, to address the gathering.
Good evening to all. There is a saying which says, familiarity always breeds contempt. Last time I was there for more than 1.5 hours. So therefore I can understand the lean gathering today compared to what it was last time. Sorry for having tortured you so long. Today, without any other creams or any other matters from personal experience, we will straight away go into that. And
this session can be seen in the YouTube. You will get in the YouTube.
We will get in the YouTube.
That's why you know most of them are not here.
Thank you for that consolation. Okay. So now we will go. Last time we explained we went through two things. One is the broad aspects of the act, and then we spoke about the speciality of the act. Probably you might be remembering. Now we will not repeat all those things. We will now go to the definitions. Now those definitions that are of more ordinary use before the sessions code and also in the applied codes, I have picked up a few. And we will go into cannabis. See, cannabis, hemp, HRS, that is a separated resin. You know what I mean by the separated resin? Probably you understand what it is. Separated resin. So therefore, in arak, in Malayalam it means arak, separated resin in whatever form. Either it could be kanjav lehyam, it could be kanjav oil, or it could be in whatever form. That is the meaning of the word, in whatever form. Whether crude or purified. So, if the resin is taken without purification, see, in Ayurveda, drugs like ganja is a medicine in many Ayurvedic formulations, kashayams, and but they don't use the ganja as such. What they do is they use it only, even in Siddha medicine it is widely used. It is used even in treatments of cancer. Siddha medicine adopts this, and as a sedative drug also there. But they use it after purification. That is what they call is, in Ashtanga Hridayam it is called as Shuddhikrama. Shuddhikrama, after that only they use it. That is the poisonous content. The poisonous content in ganja, probably you may know, that is called as the tetrahydrocannabinoid, THC content. THC content is the poisonous substance in the ganja that is removed by these methods of purification, Shuddhikrama. So in whether crude or purified, if you purify it or even in the crude form, it comes within the definition. See, this is a very expansive definition obtained from the cannabis plant. So all you have to filter up is the plant should be cannabis. Suppose you are able to say, cannabis is a genus of plant. It comes in that family. But if you are able to say from the defense evidence that it is from the other plant, although it belongs to the same family, then probably you escape. From the cannabis plant, and also includes a concentrated preparation resin known as hashish oil or liquid hashish. Then ganja, then the definition. Ganja has got a different definition under the Abkari Act. Abkari Act was the act which used to punish ganja possessions. Ganja, that is the flowering or fruiting tops of the cannabis plant. See this, see how the definition goes. That is adinte poon kai. So if you go through the magas are generally prepared by the excess people, not police people do not make it so great. If you go to the probably about ex-prosecutor will definitely know it. You might have seen masses like that. In all the masses they say that പൂവും രുചിച്ചും മണത്തും നോക്കി പൂവും കായും കണ്ടെത്തി. Mahasar will definitely contain an averment stating that the flower as well as the fruiting top. Why? Because it is because these exit people they are given training, they know excluding the seeds and the leaves. അതിൻ്റെ ഇലകളും അതിൻ്റെ കായ്കളും excluding the seed. Most of the ganja makers what they do is they take the ganja, then they do it like that, and if the seeds are there, the seeds will be removed. That is, you fill it in the, generally people used to fill it in the Wills cigarette. So when you mixed with the tobacco, but when they do that, you remove the seeds. But if you smoke it along with the seed, what happens is you get straight away headache. Seeds and leaves, when not accompanied by the tops. See how the definition goes. When not accompanied by the top. See, suppose I have a 25 kilograms, which is commercial quantity of ganja, which has only seeds, leaves, root, bark, etc. No offense is made out. But then if it has got 1 gram of flowering and the fruiting top, then what happens? It is not the 1 gram for which I go for punishment. I go for punishment for a commercial quantity. I will come to that position later. By whatever name they may be known or designated. In North India, they make a preparation called as what is it? Bang. A drink that is a drink mixed with the milk. But then, if it contains ganja, whatever name they may be known or designated. So therefore, if the certificate, normally in every 293 certificate, they don't write whether there is a fruiting or a flowering top. All that they say is that the sample is ganja. That is as defined. They don't even say as defined under the Act. But no court has recognized that. There have been decisions where it came up before Justice Bhavdas. It is an unreported decision where it was argued, very lately also it was argued that without the flowering and the fruiting tops, the possession is not an offence under the Act. Then Justice Bhavdasan said it is not like that, and overruled that argument. Very recently, before Justice Vijay Abraham and a bail application, similar contention was taken. I was in that court. The same contention that was taken by the daughter of Niharika, that is the daughter of Justice KHCAA. She took up this contention. That is, without the fruiting and the flowering top, the seeds, leaves, bark, root, etc. will have to be excluded. So I will be liable only for the quantity of leaves of the flowering and the fruiting tops. But Justice Vijay Abraham did not accept that argument. It was disallowed. I will take you to that decision. Then any mixture, see how the definition, how danger, any mixture with or without a neutral material, with a neutral material or without neutral material of any of the above forms of cannabis or any drink prepared therefrom. See, what do you mean by a neutral material? I'll explain it to you in very simple terms. See, when you go to a toddy shop, in early days when you go to a toddy shop, you are given toddy in a glass. After you take the toddy, in order to increase the, intoxication power, you light up the ganja bidi, and thereafter you dip the ganja bidi in such a manner that the ganja smoke comes through the toddy, and thereafter you inhale that, so that you get a increased intoxicant effect. That is what it means. Here, this is not here. That is not a neutral material. The toddy is not a neutral material. The toddy is a material that enhances the intoxicating power of the ganja bidi. But then suppose it is water, it is a neutral material. It does not enhance, it does not do anything with the drug, it does not interfere with the chemical properties of the ganja in any manner, but still it is a neutral material. That is why it's a mixture with or without neutral material of any of the above forms of cannabis or any drink prepared there. Now, what exactly is commercial quantity? That you know, below 1 kilogram, it is small quantity, between 1 and 20 kg, it is intermediate quantity, and above 20, it is commercial quantity. Now I will take you one very important decision. Here as in year 2020 Supreme Court 3255. This is a decision which gave a death knell to the decision in E. Michael Raj. Last session you might be remembering that we spoke of Michael Raj. And I gave you the facts also. That is a case that came up from Trivandrum Court where the argument regarding the quantity of the THC content was taken up, and only the quantity of the THC content as given in the 293 chemical certificate should be taken. That was the argument that was taken in the trial court. In the appeal court also, trial court it failed, appeal court also failed. You might be remembering the matter went to the Supreme Court, and in the Supreme Court, I remember having said that it was Mr. Vishnu, the senior counsel, who argued that case. And then in Michael Raj, fortunately, the Supreme Court came to the conclusion that we will go only by the THC content, only by the actual heroin content in the sample. So therefore, the percentage of the heroin content in the sample is taken, and thereafter the rest is excluded in order to determine whether the quantity is small, intermediate, or commercial quantity. But then just go through this decision. Paragraph number 12. This is the ratio decidendi of that decision. In view of the above and for the reasons stated above, reference is answered. This is a reference to the full court. Answered as under. The decision of this court in the case of E. Michael Raj, taking the view that in the mixture of narcotic drug or psychotropic substance with one or more neutral substance. Say for instance, very easy to understand. Say suppose it is ganja lehium, or suppose it is hashish. Hashish is pacha narthal hashish. What I do is, from B purchases, say for instance 5 kilograms of hashish from A. So the total quantity under his possession is 5 kilograms. So what he does is, say for a pinnak or kauda, almost of the same color, it's a neutral material. Suppose he takes 50 grams of the hashish from the 5 kilograms, and thereafter mixes the same with the mixes the neutral material, and thereafter makes it as 5 grams, is liable for 5 kilograms. That is what this decision says. Earlier, going by Michael Raj, it was different. Is not to be taken into consideration while determining the small quantity or commercial quantity of a narcotic drug or psychotropic substance, and only the actual content by weight of the offending narcotic drug, which is relevant for the purpose of determining whether it will constitute small quantity or commercial quantity, is not a good law. In the case of seizure of the mixture of narcotic drugs and substances with one or more neutral substances, the quantity of the neutral substances is not to be excluded and is to be taken into consideration along with the actual content by weight of the offending drug while determining the small or commercial quantity of the narcotic drugs or psychotropic substance. So therefore, once the chemical certificates say that it is heroin, hashish oil or ganja, whatever the case may be, then how we will go by the quantity? Not by the percentage of the THC content or the drug content stated by the chemist. There is no point in cross-examining the chemist. You know how do we cross-examine a chemist in a very puerile law? How do we cross-examine a chemist in an NDPS trial? You don't have a right of cross-examination, as you know, because the chemist certificate is conclusive proof. The court will have to presume that the document is valid and genuine. Therefore, if you want to cross-examine the chemist, you will have to file an application under subsection 2 of section 293, recall the chemist or call the chemist for cross-examination, and your cross-examination will be limited only to the points, that's the law, only to the point. Generally, but probable prosecutors, for matters of safety and for and on the basis of a general misunderstanding, they put the chemist also in the box, which gives us an opportunity to cross-examine on various points. Not at all necessary, because that is admissible even without examination of the chemist. That is fundamental law. So now the point is, there is no point in cross-examining the chemist as to what exactly is the drug content. So in order to find out the drug content, once the certificate tells you that it is the narcotic or psychotropic substance which falls in any of the definitions given under the Act, then what remains is in order to find out the quantity, you will have to go into the Mahasar, Seizure Mahasar. Whatever is said in the Seizure Mahasar is the quantity with which the accused is under liability. Then only then that will be taken up for the purpose of finding for the purpose of conviction, or whether it is small, intermediate, or commercial quantity. This decision gives a carte blanche to the seizing officers, because see, you have the preventive detention law in the narcotics, PIT and DPS, and the object of the PIT and DPS is for the I know that there will be difference regarding that, but then I would like to air what I feel about this. See, PIT and DPS is a provision like that. You have the 107 proceedings under the Code of Criminal Procedure, or the or in the Customs Act, etc. It is a provision for the purpose of preventing the commission of drug offences. That is why people are sponsored, and thereafter people are put in the jail as a preventive measure. So therefore, there is no question of a bail in a preventive detention matter. Now, by this decision, it is already to say this will operate as a preventive measure insofar as, say, suppose an executive officer, suppose a seizing officer wants to pick me up. All that he requires only a very small quantity of the drug of the drug which he proposes to fabricate upon me. Once he has decided on that, if he feels that I am a person who has to be put for a considerably long period of incarceration, all that is necessary is he can determine whether the quantity is small, intermediate, or commercial quantity. I suppose you understand what I say. Once it is commercial quantity, in the bail court you will not be able to say that the quantity of heroin content or the drug content in the sample is only so much and so much percentage, and therefore you are entitled only for the lesser quantity. You don't have that argument. Then what happens is, as you know, Section 37 creeps in, and once Section 37 creeps in, unless and until you are prima facie able to show that you are prima facie not guilty, and the other condition that you are not likely to recommit the offence in future, no question of bail. That means you will face the trial. You will face the trial under custody. And once you face the trial under custody, then the question of appeal comes. And when the question of appeal comes, you are immediately under the clippings of Section 32A, which disallows the appellate court from suspending the sentence provided it is a commercial quantity. So therefore, for a very long period, you are likely to be insane. This will give a carte blanche for the police to operate as a preventive measure. Whether it is good or bad, it is for persons who suffer to understand it. Illicit traffic. Now, illicit traffic has got a definite and a clear meaning under the Act. See how the Act defines illicit traffic. Illicit traffic in relation to narcotics, that it applies only in relation to that, not otherwise. Now, NDPS means cultivation. See, cultivating any cocoa plant or gathering any portion of cocoa plant. So suppose I am a worker in a cocoa plantation. I am liable for illicit traffic. Cultivating the opium poppy or any cannabis plant. I have a cannabis plant at my house in my pot for my personal use. It is illicit traffic, as per the definition of this Act. Cultivating the opium poppy or any cannabis plant, because engaging in the production, manufacture, possession, sale, purchase, transport, warehouse, concealment, use or consumption, import interstate, export interstate, import into India, export from India or shipment of narcotic drugs or psychotropic substance. So therefore, a legal fiction is created to the word illicit trafficking, and illicit trafficking can be understood only in reference to what is provided under the Act and not otherwise. That is to say, you cannot find the meaning of the word illicit trafficking from any other external aids. You must have gone through Maxwell on interpretation of statutes, external aids for the interpretation of statute. You cannot do that. Then we have the manufactured drug. Manufactured drug means, idana arthamakunnu. Manufactured drug means all coca derivatives, medicinal cannabis, nerathe njan parnja ganjavu lehyam, medicinal cannabis, opium derivatives and poppy straw concentrate. Any other narcotic substance or preparation which the central government may, having regard to the available information as to its nature or to a decision, if any, under any international convention, by notification in the official gazette, declare it to be a manufactured drug, but does not include any narcotic substance or preparation which the central government may, having regard to the available information as to its nature or to a decision, if any, under any international convention, by notification in the official gazette, declare not to be a manufacturer. This relates to notified manufacturer drug, ephedrine, that is now a controlled substance. For controlled substance, there is a specific provision in the NDPS Act, that is section 9 capital A. Then preparation in relation to a narcotic drug or psychotropic substance means any one or more such drugs or substance in dosage form or solution or mixture in whatever physical state containing one or more of such a drug, that is, you mix two drugs together, or drugs or substances. Then psychotropic substance means any substance, natural or synthetic, or any natural material, or any salt or preparation of such substance or material included in the list of psychotropic substances in the schedule. For instance, MDMA, which I spoke of last time on case which I referred to. See now, lab technicians. I don't have the who do the, that is lab chemists, who are very well qualified in chemistry. That is drug makers. It is one of the most important and highest paid job in the world, because you take the schedule, and in the schedule you have a formulation for a psychotropic substance. Only those psychotropic, see how only those material included in the list of psychotropic substances specified in the schedule. So therefore, you add, you change the chemical carbon bonding of the substance, you add one molecule or whatever it is, so therefore the structure of the drug changes so that it is not reflected in the list, but then it has better effect. It has better effect, and then it goes into the market very soon. When the matter comes before the court, you can immediately take out the list and say that in the list it is not included. Kindly go through these two cases. Rajinder Gupta on Biprin or fine, 2006 Criminal Law Journal 1674, 1997 Criminal Law Journal 3104. That's a case where the question arose whether buprenorphine hydrochloride, whether it is a psychotropic substance or not. Kindly go through that decision. Now we will go to section 32A. No suspension, remission or commutation in any sentence awarded under the Act. Notwithstanding anything contained in the Code of Procedure 1974, as you know, where is the suspension remission powers of the are found in the CRPC 433 proceedings, you know, and then the governor's power under Article 72 and the power of the central government under power of the governor under Article 162, and the other is the power of the president under. I am very poor in constitution. I think it is Article 72. So nothing contained in the Code of Procedure or any other law for the time being in force, but subject to the provisions of section 33, no sentence awarded under this Act shall be such that the jail authorities do not have any powers of remission. The governor does not have any power. That question came up in Tufan Singh. This is one of the classic decisions, and nobody other than Justice Rondon Nariman can write a decision like this, write a judgment like that. It's very pathetic that he went out of the judiciary. He had a very early retirement. See, Section 32A. Section 32A excludes the application of the code, although there is interplay between the code and the Act and several provisions. Studied Section 32A, and in Tufan Singh, that is a division bench ruling. We will come to Tufan Singh later. It has got so many other. It deals with the power, the admissibility of the statements recorded under section, taken under section 67, statements recorded under section 53A, then the difference between authorized officer, empowered officer, etc. It is a very exhaustive decision dealing with almost all the provisions in the Act. Then 2015, 16 SCC 280, the provisions in the Punjab jail manual, that is, the question arose whether the provisions in the jail manual giving right for persons who have undergone a sentence of probably more than 1.5 years or 20, if their character and conduct is good, then the jail authority has got the power to give them parole. Then the question arose whether they could be given parole. Then the court said that this jail manual provisions fall under section 32A, and the jail manual is a subordinate legislation. You know the difference, you may have studied in jurisprudence. What is the difference between a subordinate legislation, delegated legislation, etc. Fundamental law. Okay, now we will go into a classic decision of the Supreme Court in Dadu's case. This is just authored by Justice K.T. Thomas, a year 2000 Supreme Court 3203. Section 32A was struck down. Section 32A had two parts. We will go to section 32A. One minute. Yes, notwithstanding anything contained in any other law for the time, but subject to the provisions, no sentence awarded in the act shall be suspended. Then it related to the question whether the power, the bar under section 32A applies to the court or not. That was the situation. Then to that extent, section 32A was struck down as ultra vires. Then Jalaluddin, 32 was struck down as ultra vires because it gives the power of the appeal court to suspend the sentence, and the parole is not a suspension of sentence, so therefore poor persons who are locked in the prison, they are given parole. Then Jalaluddin, that is also a decision, 2007 Kerala High Court cases 3435. The court has the power to suspend the sentence in an appropriate case subject to the restrictions contained in the section 37. Otherwise, what happens is a person who has been found guilty for a intermediate quantity of ganja, although he is entered for bail at the time of crime stage or even after during the trial stage, his sentence cannot be suspended by the appeal court once he is found guilty. So therefore, in order to avoid that anomaly, this decision is done. Then section 35. This is a case of a reverse presumption. In any prosecution for an offence under this act which requires a culpable mental state of the accused, the court shall presume the existence of mental state, but it shall be a defence of the accused to prove the fact that he had knows his mental state with respect to the act charged as an offence in that position. What do we understand from that? You know that the fundamental principle, the first principle of criminal law is that mens rea. You must have the requisite mens rea. For an actus reus is not sufficient to find you guilty. So therefore, the question of mens rea is important. But suppose you are involved in an accident case where there is a prosecution against you for having caused the death of a person by rash and negligent driving. Clearly, mens rea is out of question, isn't it? You cannot take up a defense in an accident case stating that you did not have the mens rea at all. The accident has taken place and if death has come, clearly you come under the clip of section 304A, and the only defense that is available to you once your identity is proved in the trial court, only defense available to you is that you did not act rashly or negligently and there was no rashness or negligence on your side, etc. That is the only point on which you can argue the case. Similarly, here is a case where there is a reverse presumption. See, that's a reverse presumption. That is, once the prosecution show or prove the foundational fact, that is to borrow the words of Justice Sunil Thomas, the foundational fact. What is the foundational fact? The seizure of the offending article from your possession. Once the prosecution succeeds in proving that the foundational fact is proved before the court, then the burden immediately shifts. That is as good as saying that it is a special fact which is in the knowledge of the accused, as though you come under section 105 of the Evidence Act, where special facts within the knowledge of the accused has to be proved. So therefore the general rule of burden of proof under section 101 of the Evidence Act is obliterated. In this section, culpable mental state includes intention, uddesham, includes intention, motive, motive, knowledge of a fact, arvu. I am sitting in the car where in the dicky there is 28 kilograms of ganja, and I am sitting as a person inside the car. Then the question is whether I have the knowledge. The question is whether I have the animus possidendi. What does the act presume? They are once the seizure of the ganja article from the car, from the boot of the car is proved against you, and then it is proved, and your identity is also proved before the trial court, then the trial court will presume that you have the knowledge that what was kept in the boot of the car was narcotic drug amounting to such and such quantity. Otherwise, you will have to rebut the presumption by giving reverse evidence. That is, you will have to prove a negative fact. For the purposes to see this, then qualifies, say, culpable mental state is qualified. For the purpose of this is what is the quality of the evidence. For the purposes of this section, a fact is said to be proved only. See the word only. What is the significance of that word only? Only when the court believes it to exist beyond reasonable doubt. സംശയത്തിൻ്റെ കാർമേഘങ്ങൾക്കെല്ലാം അപ്പുറം, beyond reasonable doubt, and not merely when its existence is established by a preponderance of probability. This is a fundamental deviation from the general criminal law. In the general criminal law, suppose A and B quarrel, Shivangutti versus State of Kerala, which was decided by Justice P. Govindas very recently. Shivangutti versus, that is a case where the deceased was walking through a lane near the house of the accused, and there was some previous enmity. Then there was a fight ensued in which the son, daughter and wife of the deceased also intervened. There was a fight, and in the fight the accused took a knife and gave a stab. Question was whether there was private defense. And then his lordship quoting Moitra on private defense. It's a very, very good book. It will be available. So when our Supreme Court was formed, Madhu Gondapala went to the Supreme Court to argue a criminal case. This example was told to me by my senior Kotur Gopaleshwara. I have never seen Madhu Gondapala. And Madhu Gondapala went there, and then he was arguing a question on private defense. And when he was arguing the question of private defense, then he said the benefit of doubt of private defense. Then the judges of the Supreme Court said, we have heard of the private defense. But what do you mean by the benefit of doubt of private defense? That is an unheard of principle. We have never heard of it. Then Madhu Gondapala in his individual style said that if you want to know what is the benefit of doubt of private defense, there is a book written in 1920 by Moitra, which is available in the Supreme Court library. Then they took the book, and in the book there is a discussion of the benefit. If the court has got, from the facts proved, if the court has got a doubt whether the act of the accused falls in the realm of private defense or not, that is called as a benefit of a private defense. But the benefit of the private defense, borrow the words of Justice Chandra Nair, is the doubt of a rational mind, and not the doubt of a vacillating mind. A doubt which is inferred from the logical deduction, logical inferences from the facts proved in the trial. Now anyway, so his Lordship Justice Govinda got the book from our library, and in that decision, Shivangutti versus State of Kerala, that Moitra is quoted regarding the rule of the benefit of doubt of private defense. True, benefit of doubt of private defense is later on in 1965 also. Who became the Vice President of India, who was the Chief Justice, Hidayatullah's golden rule of scale, weighing the private defense in the golden scales, etc. There you get the theories. These theories are there. You should not weigh it in a golden scale. Sorna Tulasil and a Tokerede, no worry. Kaltirala Tokalale, the evidence. Okay. So now we were on that culpable mental state. For the purpose of this section, see. Therefore, we were on the benefit of doubt of private defense or on the question of private defense. See, in order to prove the question of private defense, all that is required is you need not jump into the box and prove that you did the act with the private defense. You need not examine any witnesses to prove that point. It's all pure law, which you know. But from the facts, Suppose it is not. I still remember a case where my senior was a taxi driver, Beni Gopalishan. He was a taxi driver near the Fort High School, and he had a very beautiful wife. And he, after his taxi running is over, he comes home, and every day he goes to a pan shop, lights a cigarette, and then he walks. A very peaceful man. And what happened was Gopalishan there. The time went, and then he just bought one cigarette, just lighted the cigarette and took one drag. One fellow who was standing next to him, he said, in Malayalam he said, his wife is a very beautiful woman. I accused his wife. So immediately he got the hint of it. Then immediately he turned back and said, then he got violent. He parked the knife on it, generally very sharp. By having cut a number of the betel nuts, this knife becomes very sharp. Took the knife and gave one bloody stab. And when it pierced his heart, and the pericardium got away, he died on the spot. And the incident was written in the FIS, fortunately saying that there was a quarrel. And in the quarrel that ensued, the accused took the knife and inflicted the stab injury. I still remember I was with my senior who argued the bail application before Justice K.T. Thomas, as he was my district judge that time. Then my senior was arguing this, and then I still remember His Lordship having gone through the first information report. Case diary will be produced by the PP before the district judge. So on going through the FAC, Mr. Govindan, you have got an excellent case of private defense. Why don't you argue that? My senior said, yes, Your Honor, I am arguing that only. Bail was granted. Okay. So what I said was, see, we were on the question of private defense. So you cannot say private defense. You cannot see if you are in a drug case like that car case which I said. You cannot say that, see, all that evidence would show is that the detecting officer seized 28 grams from the boot of the car. Then I was sitting in the car, true. I was identified by the seizing officer, and also the independent witnesses, alleged independent witnesses who spoke in the court also identified. I agree. What is there to show that I did have the knowledge that what was there in the car in the booty was ganja? It's a prima facie, it appears to be a very excellent argument, but in a trial under the NDPS Act, the court cannot allow that argument because of this problem. The court will have to find that fact, that is, he did not have the knowledge that the ganja was secreted or concealed in the body, and he was an innocent passenger in the car, was a knowledge he did not have, provided there is not by beyond a reasonable doubt, provided it is proved beyond reasonable doubt. It is impossible. How will you prove it? What is the technique to prove that? I fail to understand how it is possible. You can only bring around, as you gallop a horse, you know that so much dust comes in. And the more the dust, the horse will be unseen. Similarly, in a criminal trial, as your cross-examination proceeds, you try to rake up a lot of dust. And the more the dust, then the prosecution case against you is clouded. Then you say, doubt. You can't see the prosecution case. You can't see that I am guilty. All that you can see is the dust. And in the dust, you can see through and say that I am guilty. You can't say that. You cannot have that argument. It's a case of reverse presumption. Year 2020, same, Tufan Singh. Justice Rohinton Nariman, read that judgment. Justice Rohinton Nariman discusses this point in very, very clear terms. There, then year 2017, Supreme Court 3859. There, reverse burden does not sanction conviction on probabilities and the presumption is rebuttable. There also Supreme Court understands the problem of proving a case, proving a defense beyond reasonable doubt. It's something that is an impossible thing which you can do in a trial court. In any trial where such is the statute. So therefore the Supreme Court said that the presumption is rebuttable. But I don't know how you can rebut the presumption by giving, how can you say that I did not have the knowledge? I can say, I can prove that I did have the knowledge. But how can you prove that I did not have the knowledge? So it's almost an impossibility. But then in Nooragha, 2008-16, SCC 417, para 58. Kindly read that. Nooragha is a wonderful decision, because in Nooragha, the Supreme Court went on to say that the statements, 53A, 67 statements, were not admissible as confessions, and it cannot be read into evidence. That to that extent, that decision has done a lot of good to defense lawyers. But then the constitutional validity of this provision was challenged, but it was upheld. Section 36A. This is a very important case, very important provision, because this provision lays down the investigation as well as the trial procedure under the Act. Yesterday, last session, you remember that I said about the speciality of the Act. I said that here is an Act, here is an Act, you call him a human being, but he does not have any quality of the human being. He does not have nose, he does not have ears, he does not have eye, he does not have any emotions, no sentiments, nothing. This is an Act like that. You call him an Act, but it does not, criminal statute, but it does not have any qualities of a criminal statute. These are all provisions that come under the Evidence Act regarding the proving of a fact. But then it should go under the evidence provisions, but it comes in the procedural law. Anyway, probably times might need it. That may be the reason why the legislature has found it fit to enact it. And I am not the person to question it here. See, notwithstanding anything contained in the Code of Criminal Procedure, how do you understand or how do you interpret the word notwithstanding? What does Maxwell say? That is, you exclude anything else. I still remember a lawyer was arguing a case before a municipal court in Trivandrum. Allow me. He said, what's the meaning of the word notwithstanding? Means, വേറൊന്ന് നിയമത്തിൽ എന്ത് തന്നെ പറഞ്ഞാലും ഇവിടെ ഇതാണ് നിയമം. That is what it means. Very simple. വേറെ എന്ത് നിയമത്തിൽ എവിടെ എന്തെല്ലാം പറഞ്ഞാലും ഇവിടെ ഇതാണ് നിയമം. Notwithstanding anything contained in the Code of Criminal Procedure, then ഇതാണ് നിയമം. Offences under the Act which are punishable with imprisonment for a term of more than 3 years. 3 വർഷത്തിന് മുകളിലുള്ളതെല്ലാം shall be triable only by a special court constituted for the area in which the offence has been committed, or where there are more special courts than one for such area, by such one of them as may be specified in this behalf by the government. Very clear, no? That is trial by special courts only. Ordinary Sessions Court cannot try you. Suppose an ordinary Sessions Court tries you, what happens? An ordinary Sessions Court tries you. What is the difference between an ordinary special court, Sessions Court and a special court? A special court is a notified court. A High Court empowers the said courts with a sufficient notification so as to make them as special judges under the Act. So if they try you, then the trial becomes void. The trial becomes void, and the conviction and the sentence has no recognition under the eye of law. Where a person accused of or suspected, very important provision, or commission of an offence under this Act is forwarded to a magistrate. Let us understand what this means. That is, suppose I pick it up on charges of possession of a narcotic or a psychotropic substance. Arrested. What should the arresting officer do? I should be forwarded to where? To a magistrate. That is, a magistrate means not to the special court. I must be forwarded to the magistrate, not to the special court. Forwarded to a magistrate under subsection 2 or subsection 2A of 167 of the CRPC 1973. Such a magistrate may authorize its detention of such a person in such a custody. What do you understand by as he thinks fit? That is, suppose the narcotic control seizing officer files an application for police custody. That is the meaning of such a custody. Such a custody means either there are only 2 types of custodies. That is, police custody and judicial custody. Judicial custody. പോലീസുകാരൻ്റെ കസ്റ്റഡിയിൽ എന്നെ കൊടുക്കണോ വേണ്ടോ എന്ന് തീരുമാനിക്കാനുള്ള അധികാരം ആർക്കാണ്? It is the magistrate. Why so? Because of the Anbamkar's decision. You might be knowing that in Anbamkar versus CBI, the Supreme Court said that police custody application has to be filed within the ആദ്യത്തെ 15 ദിവസത്തിനകം it should be filed. Okay, so therefore it says, that is why this power is given to the magistrate. Otherwise what happens? the party will be inside the jail for a period of 14 days. Then he goes to the special court. When he goes to the special court, the special judge will have no jurisdiction to grant police custody. May authorize detention of such person, such custody as such things fit for a period not exceeding 15 days in the whole, where such magistrate is a judicial magistrate, and 7 days in the whole, where such magistrate is an executive magistrate, provided that in cases which are triable by the special court, where such magistrate considers when such person is forwarded to him as aforesaid, or upon any time before the expiry of the period of detention authorized by him, that the detention of such person is unnecessary, he shall order such a person to be forwarded to the special court having jurisdiction. Allow me to speak on this point a little bit. That is, suppose you are forwarded to the magistrate with a seizure report Magasar, with an over if it is a customs excise or a narcotic officer case, or an FIR and a remand report if it is by the police. And then on the expiry of the period of the first 15 days, the police or the seizing officer do not file a remand application, remand extension period. Can he be released on bail? Under law? No. You cannot be released on bail. The magistrate has no power to release, provided the case is one that has to be tried and disposed by the special court. അത് 3 വർഷം കൂടുതൽ ശിക്ഷ കിട്ടാവുന്ന ഒരു കുറ്റമാണ് മജിസ്ട്രേറ്റിൽ നിന്ന് റിമാൻഡ് റിപ്പോർട്ടിൽ നിന്ന് വ്യക്തമാകുന്നുണ്ടെങ്കിൽ you cannot be granted bail by the magistrate despite notwithstanding the fact that there is no remand application. What should the magistrate do? He shall order such a person to be forwarded to the special court having jurisdiction. നിർബന്ധമായിട്ട് 15 ദിവസം കഴിഞ്ഞ് കഴിഞ്ഞാൽ ഇത് ചെയ്തേ പറ്റൂ. The special court may authorize in relation to the person forwarded to it under clause B the same power. So therefore what happens? The special court relegates himself, like that of a PC Act offence, he relegates himself to the status of a magistrate. Why? Because he wants to exercise the powers under section 167 of the code. Under clause B, same power which a magistrate having jurisdiction to try a case may exercise under section 167 of the Code of Procedure 1973 in relation to an accused person in such case who has been forwarded to him under that section. Very interesting question of law comes in which has not yet come. Say, take that for the first 15 days the police have not filed for a police custody. You are forwarded to the special court. 15 days over. Then the law says that the magistrate, the special court has got the special court has got the same power as that of a magistrate under 167. Now 167 say that the magistrate has got the power to put you to such custody, either judicial or police. But Anupam Kher says otherwise. Anupam Kher says after 15 days not possible. Anupam Kher restricts itself to police custody applications before the magistrate. Am I correct? Now you come before the special court. In the special court, the narcotic officer comes and files, the seizing officer comes and files an application for police custody. Can it be allowed? It can be, by reason of section 309 of the CRPC, because he exercises power under section 309 as well as under section 167, and the law say that the provisions under section 51, so far as they are inconsistent with the act, are applicable. See how dangerous the act is. That of Michael Jackson's famous album, Dangerous. Yes, special court may, upon perusal of the police report of the facts constituting an offence under this act, or upon complaint made by an officer of the central government or a state government authorized in this behalf, take cognizance of the offence without the accused being committed for trial. You know the general provisions for sessions trials, isn't it? If the cases where the magistrate is competent to try, cases where the special judges, the sessions court is competent to try, but session judges are not judges with the original court of jurisdiction. The sessions court do not have jurisdiction to take cognizance of an offence under section 190. So therefore, there is a provision made in the CRPC under section 193 for committal of the case by the concerned jurisdictional committal magistrate. That is now excluded by this provision. Section 193 is excluded. When trying, so see, without the accused being committed to it for trial. Pratyeka committee and കാര്യമില്ല. When trying an offence under this act, the special court may also try an offence other than an offence under this act with which the accused may, under the code of procedure, be charged at the same trial. See, take a case where that Mr. Arun and both of us are drug peddlers, and Arun has stocked a huge quantity of narcotics in his office. I go there, I ask him the share, and then there is a fight ensuing between us. There is a gun duel. I take up the gun and shoot him down. Offence under section 302 IPC. Offence under the narcotics also. The police charge both of the police charge me is that the police charge me. The police charges me for an offence under section 302 IPC and also for drug possession. Am I right? Okay. Then what happens to me? What happens to me? The policeman can produce me before the magistrate first. And once I am produced before the magistrate with a huge seizure of drugs from the office of Arun, along with his dead body, post-mortem, inquest, etc., what happened? Prima facie, there is a report of murder as well as an offence under the NDPS Act. Then what should the magistrate do? By virtue of this section, subsection 2, the magistrate will forward me to the special court. And when I am forwarded to the special court, he can charge me for, he can try me without me being committed for trial. I cannot go before the special judge and say that, look here there are two offences. One murder, agreed. I took up my gun and shot him dead. Right. But then what the other is NDPS offence. The NDPS offence should be declubbed and it has to go to the special judge. And the murder offence shall go to the magistrate. So I should come under the regular committal order. Not necessary at all. Sufficient that it is so much that it is intrinsically woven together. It is a part of the same transaction. I can be tried by the special court, and the special court is given this power in order to take note of such a situation. Then nothing contained in this section shall be deemed to affect the special powers of the High Court regarding bail under section 410 of the Code of Procedure, and the High Court may exercise such power, including the power under clause B of section 1 of that section, as if the reference to a magistrate in that section included also a special court constituted under section 36. Probably you understand what it is. But then I will ask one question. Suppose in the special court I file an application for bail. In the instance which I said, an application for bail is filed by me. Then probably the prosecutor, say Mr. Santosh will get up and say, Ajith Kumar is charged for NDPS possession, commercial quantity. Section 37 I am posing the bail. Unless twin conditions are satisfied, this court has no jurisdiction. Correct. What about offence under section 302? 302, my bail application will be considered deholds the section 439. Am I correct? So 302 I will get bail, but for the other offence I will remain in prison. That is what they say. The power of the magistrate, the power of the special court under section 439 is preserved. But that is, we will come to section 37 later. Then what happens if the offence is a narcotic offence? If it is a narcotic offence, then the bail jurisdiction of the concerned judge is limited to the extent section 37 allows. Otherwise, no. In respect of persons accused of offence punishable under section 19 or section 24 or section 27 or for offences involving commercial quantity in reference in subsection 2 of section 167 CRPC thereof to 90 days where they occur shall be construed as a reference to 180 days, provided that if it is not possible to complete the investigation within the said period of 180 days, the special court may extend the said period up to 1 year on the report of the public prosecutor indicating the progress of the investigation and the specific reasons for the detention of the accused beyond the said period of 180 days. Very beautiful provision. One case, Rennie's versus, I think you oppose the bail application. Rennie's versus State of Kerala, which is very using now. Very recently, he was caught with 13 lakhs and a huge quantity of contraband from a hotel from Manandara. Then his period was over, 180 days was over. Fortunately, the application was filed by the investigating officer. Remember that case? Application was filed by the investigating. The trial court we took up the contention that, see, if the application is by the IO, then it is violation of the section. See, what the section says that the application for remand extension will have to be filed by the public prosecutor. But then here there is a proviso. What is the role of the public prosecutor here? He is a post office of the IO. Should he call for a report from the IO? No, according to me, no. The public prosecutor in this case plays, to borrow the words of Justice Tenaparedi, a dynamic role. Why? Because the public prosecutor can call for the case diary and he will determine whether there are specific reasons for the continued detention of the accused. He has got the power. He is a man in the game here, not the investigating officer. He is not a pawn at the hands of the investigating officer. The discretion whether the period of 180 days should be extended or not has to be determined by independent application of mind by the public prosecutor and not at the dictation of the policeman concerned. He is not a spokesman of the police. That is why the law says that it is on the report of the public prosecutor indicating the progress of the investigation and the specific reasons for the detention of the accused. So even that it is his reasons that are necessary, not the reason of the policeman concerned. The policeman may say, as I said yesterday, Savitri Chodin Cheyidilla, Mattavare Kittiyilla. Those are all irrelevant. It is the reasons that is pointed out by the public prosecutor that is relevant. Therefore, in a case where an application for extension is sought, it is always upon the defense lawyer to challenge and say that the report does not reflect the independent application of the mind of the public prosecutor concerned. It is nothing but a post office of the concerned police officer. So therefore, it does violation with the section 36. Notwithstanding anything contained in the Code of Criminal Procedure, the offence is punishable under this Act with imprisonment for a term of more than 3 years, may be tried summarily. You know what is the difference between a summary trial, warrant trial, session trial? I think you know, those are all basics. In summary trial, you only write down the substance of the evidence, not the entire evidence. And the cross-examination itself is limited. 3 വർഷം താഴെയുള്ള offence ആണെങ്കിൽ it can be tried summarily. Kindly go through this Tufan, AR 2020-5592. This provision enacts a special scheme. This is the words of Rohinton Nariman for the trial of offences under the Act, which is totally different from the CRPC. Earlier, in 1994, Justice Natarajan said that the NDPS Act is a complete code by itself. Then, no previous sanction to file a complaint for an offence under Section 58. What is Section 58 of the NDPS Act? Say, suppose a person does a vexatious act. I am talking here, suppose a narcotic officer comes here, pulls me out from here and takes me to his office, then plants a drug on me and forwards me to a magistrate concerned. Vexatious arrest. So, no previous sanction to file a complaint. But then, see, why this is so? Why Justice Nariman said that is because, suppose I am standing in the road and then I pick up a quarrel with the policeman who is on traffic duty. And then he beats me. I come up with the allegation before the magistrate. Policeman will come up and say, see, my act is under the colour of my office, purporting to act in the colour of the office. He will say. And therefore, 197 of the CRPC protects me. Provided he is an officer appointed by the central of the state government, not by a policeman, but a person who is superior in rank to such a degree. He will come and say. Now, suppose it is a PC Act case. It's a PC Act case, then he will come and say that unless and there is sufficient sanction under Section 19, no complaint will lie. No complaint, no prosecution will lie. But that is taken away when there is a complaint under Section 58. Suppose I file a complaint before the magistrate, then that complaint need not have a previous sanction. Then kindly read this decision. Shravan Kumar, 2012 Criminal Journal 1480, Rajasthan. This cuts open a new revelation. This what happened was, here the police put up a person for trial, and during the course of the inquiry, the special court decided that another person also should be included. Then what he did was, he caught up that person also and joined him in the trial. That was challenged in Shravan Kumar. But unfortunately, Rajasthan High Court said that the special court has powers. You might be knowing how a person can be added during the proceeding. Which is that provision? Section 319 of the 319 in Om Prakash trial. I remember Indira Madam, she brought in another person during the course of the proceedings by invoking her power under section 319. But 319 is under stay by the High Court. Now 319 comes into operation only when there is evidence recorded in the trial. There is evidence. Suppose the court say that the person standing in the dock as well as the person standing outside the court committed the murder. Once that evidence has come in, then only the learned judge can invoke the power under section 319 and thereafter join in. But then unfortunately this decision has not gone into the powers of the court under section 39 and the procedure to be adopted therein. Unfortunately, there is no provision under the NDPS Act similar to section 319. So therefore, by junction of section 51 of the NDPS Act, the provision under section 319 will operate, and therefore the rules contained therein also, the principles contained therein also should be adopted. Then this is a case on bail regarding extension of the period. This is a Kerala decision. Okay, Justice KT Shankaran, 2009-4 case. This was a case where it was argued that the determination of the commercial quantity, intermediate quantity or small quantity can be determined only after there is evidence before the court that what is seized from the hands of the accused is either a narcotic substance or a psychotropic substance, and in the absence of such a certificate, it cannot be determined that he has to be remanded for a further period. On that, taking note of that argument, His Lordship Justice Shankaran, Justice KT has granted him bail. Ashraf KK. ഇതൊക്കെ ആകാശത്തുള്ള മിന്നി മറിഞ്ഞു പോകുന്ന നക്ഷത്രങ്ങളാണ്. എത്ര കാര്യം ഇനി ഉണ്ടാവും എന്നുള്ളത് ദൈവത്തിനറിയാം. These decisions. This is a decision. Sanjay Kumar KDR, very important decision. Kollavanur decision. 2009-17 SCC 639. Application for extension of remand do not comply with the section 36(4) is not allowed. So remember the principles which I said just earlier, that is public prosecutor exercising the mind, report of the public prosecutor, that he is not a spokesman, etc. Application filed with the police not to be allowed, etc. This was discussed in Sanjay Kumar KDR, authority for this point. Then we come into this notorious section 37. Offences to be cognizable and non-bailable. Notwithstanding anything in വേറൊന്ന നിയമത്തിൽ എന്ത് തന്നെ പറഞ്ഞാലും ഇവിടെ ഇതാണ് നിയമം. Notwithstanding anything contained in the CRPC, that is, notwithstanding anything contained in 439, notwithstanding anything contained in 437, അവിടെ ഒന്നും നോക്കേണ്ട കാര്യമില്ല. Borrowing the words of justice, that is why in Berlin Joseph 1994, Justice KTT, His Lordship said that section 37 starts with this, what do you say, obstante clause, like non-obstante clause. Notwithstanding anything contained in the CRPC, I am a criminal lawyer, not a civil man. That is every offence punishable under this act shall be cognizable. What do you mean by cognizable offence and a non-cognizable offence? What do you mean by cognizable offence or a non-cognizable offence? Very simple things. Police can arrest with a warrant and without warrant. Okay. No person accused of an offence punishable for 3 years. Offence under section 19 or 24 or section 27A, and also for offences involving commercial quantity, shall be released on bail or is on bond unless one public prosecutor has been given an opportunity to oppose the application for such a release. Okay, good. That's okay. And where the PP opposes the application, PP needs to oppose the court is satisfied that there are reasonable grounds for believing that he is not guilty of such offence and that he is not likely to commit any offence on bail. Actually, this section does not have any logic at all. Suppose I am arrested and the court say that prima facie I am not guilty. That means Pradama Drishtiya I am kuttakaranalla. Then where is the question of the recommission of that offence? There is no offence against me. Pradama Drishtiya, there is no offence. Then where is the question of recommission of that offence? Illa, it's like finding a black cat in a dark room which is not there. Where the public, this is why this is not very what you call as the drafter's evil. Where the public prosecutor opposes the court is satisfied, yes, believing that he is not guilty of such offence and he is not likely to commence any offence. So, twin conditions. Then it says, the limitations on granting bail specified in clause B of subsection 1 are in addition to the limitations under CRPC or any other law for the time being. So what this section has done is, this section has gone into section 437 and thereafter built a law for itself. regarding the power of the court to release a person on bail. Kindly note this decision. This is a case of Union of India versus Jitendra, 2021 10 SCC 789. Bail order was granted by the magistrate by the court below without looking into the question whether it is commercial quantity. Unfortunately, the SLP was dismissed because it was delayed by more than 607 days. But then the Supreme Court said that narcotic officer kedire 27 post vadichu avanedire nadavadi edukkan paranju. Second head note, narcotic NDPS section 37. High Court allegedly granted bail without considering the mandatory requirements of section 37. Delay of 607 in filing appeal against bail. Continuation of bail rejected. Cost of rupees 25,000 imposed to be recovered from the officers. In view of the numerous such decisions, Director General NCB directed to take remedial action. Okay. State of Kerala, Mohammed Palekil's case. 2026 KHCAA 462. Section offence involving commercial court, grant of bail. Magistrate granting bail to the accused and reason cited is accused is 21 years. Very sorry. You understand why I am sorry? That's it. Offence involved grant of bail. If public process, then the Supreme Court said this is then Labubu Mubarak versus. This is a case 2018 KC 4639. Where there is infraction. You know what is section 50 is? Last time we will come to that later. Okay. Where there is a prima facie infraction of section 50, then that is a ground for granting bail. 2018 KC 4639. Rigor applies to section 27A offences also. Yes. Then kindly take these decisions. I am not going to tell you about these decisions. This is netil available on judges' orders. You know how to take it, right? High Court website you can get it. BA number 5016 latest points on these decisions in these bail decisions the entire law regarding section 37 is discussed by the judges. I am not going to take your time at all. It's already 6 o'clock. BA number 5016 of 22, 2566 of 22, 4347 of 22, 4357 of 22. 22. Kindly read these orders. 5016, 2566 and 4357. Then Mohammed Abid, 2021 case 645. Reasonable, beautiful decision by Justice Raja Vijayaraghavan. In fact, I will stand up and give you kudos for that. Please read the decision if you have not read it. And no judge in India has written a judgment like this. That is, he went beyond the prima. What do you mean by prima facie ground? Probably he must have asked himself. And he said, prima facie grounds mean, reasonable grounds mean substantial probable cause of belief. A beautiful decision. Substantial. I must feel that there is substantial probable cause of believing the accused. I think it was argued by Babu sir. Reasonable grounds mean substantial probable. Please read this decision. I was just checking up the entire net. Nobody has quoted this decision. Nobody, no High Court has quoted. Nobody has quoted this beautiful decision where His Lordship has granted bail involving a commercial quantity. Reasonable grounds mean substantial probable cause of believing the accused guilty. ഇതിനകത്ത് ഞാൻ പറഞ്ഞ ബെയിൽ ആപ്ലിക്കേഷൻ ഈ ബെയിൽ ആപ്ലിക്കേഷൻസ് പറഞ്ഞില്ലേ 50 16 25 66 41 47 435 ആ ബെയിൽ ആപ്ലിക്കേഷൻ ഒരെണ്ണത്തിനകത്ത് he was an HDFC agent. He came there for the purpose of collecting HDFC EMI collect ചെയ്യാൻ വേണ്ടി വന്നതാണ്. Then there was a recovery from that flat. And then fortunately in that Magasar, I produced the Magasar also. Fortunately in the Magasar, the article was recovered from the Alamara. Where is the key of the Alamara? So therefore, nobody could. So they were the one bail was granted in that. Okay, grant of bail does not mean that he is not guilty as understood under section 35 of the code. That is, His Lordship said that once, even if bail is granted, then that does not mean that he need not be tried. He can be tried. Trial will take place. The prosecution has got still another opportunity to prove that he is guilty after completion of the investigation. So the bail order does not affect the prosecution in any manner. Beautiful decision. Section 42, 43, Section 42, 43, 50, 52, 52A, 51, 53A, 54, 55, 57. We will group together all these fellows together. Okay. Now, this is the first decision. 1994 Supreme Court, 1872. Okay. This is the first decision where the Supreme Court analyzed, circumcised the various provisions of the Act and understood what exactly is the provision under the Act. First see the first head note, section 100. You know what is section 4 of the CRPC? You know it? That is, trial of offences under the Act shall be tried according to the provisions contained in the code, and IPC offences shall be tried according to the provisions of the code, and offences under other acts like the ED offence, like the customs offence, like the excess offence, and like the PC Act offence, etc. shall be tried according to the provisions contained in the special law. So therefore, when you make a special law, you come under the special procedure. If you are under the IPC, you come under the regular IPC. Now, section 4, section 100, searches. Section 165, search of place. Search and seizure are applied when not inconsistent with the NDPS Act, carried out by police officer in normal course of investigation to offence or suspected offence as provided in the CRPC. On the chance recovery of narcotic drug or psychotropic substance, the empowered power from such officer from such stage onwards carry out investigation as per the provisions of the NDPS Act. To such section 50 of the NDPS Act is not applicable. Have you understood that? That is, suppose you are a police officer. What happens in the evening by around 8 o'clock or by around 8 o'clock you for a regular patrolling. And if you are going for a patrolling, one fellow is found standing near the bridge, and as the police sub-inspector there, it's there are the sub-inspector. Ajith, okay. Then he then he gets narcotic substance. Okay, MDMA from my pocket. There is a stamp from my pocket. Is the recovery, should he comply with section 50? Should I comply with section 50? No. Although the recovery is from my body. Or take another extreme case where എന്താണ് സംസാരത്തിന് സംസാരിക്കുന്നത് എന്താ നീ മര്യാദ സംസാരിക്കും ഒന്നുമില്ല ഉടനെ then immediately catches my mouth അപ്പോൾ തന്നെ വായിക്കാൻ സംസാരം എടുക്കുന്നത് ഓക്കെ അപ്പോൾ സ്റ്റാമ്പ് എന്നെ കണ്ടപ്പോൾ നീ എടുത്ത് അകത്ത് വെച്ചാണ് അല്ലേ ക്ലിയർലി സെക്ഷൻ 50 അല്ലേ റിക്കവറി ഫ്രം ദ ബോഡി ഷുഡ് സെക്ഷൻ 50 be complied? No. Why? As per this decision, that is the police officer in normal course of investigation into offence or suspected offence as provided under CRPC. It's an arrest under 41A. CRPC on the chance recovery. Why would you know stamp on the chance recovery of narcotic drug or psychotropic substance, the empowered officer from such stage onwards carry out, then the further investigation should be carry out investigation as per the provisions of the NDPS Act. To such section 50 of the Act not applicable. Para 6 and 66. Read for yourself. NDPS then section 41(1)(2), 42(1), search and seizure. Empowered or duly authorized officers. Procedure under section 42(1), search between sunset and sunrise, record the grounds of belief, held mandatory in nature. First decision which said that infraction of section 42(1) or 41(1) is Euler Waldemar versus State. That is the decision by Justice V.K. Mohan. Kindly read that. It's a case where 42(1) infraction was found and the accused was acquitted. Record the grounds held mandatory in nature. Contravention would affect the prosecution case and initiate the trial. Then section 165, search and seizure. Empowered officer or an authorized officer under 41(2) of the NDPS Act carrying out search will strictly comply. Section 100 and 165 CRPC, Justice Natarajan's decision. No strict compliance. Search would not be illegal. Then 41. Then search and seizure. Imperative requirement of the officer intending to search to inform the person to be searched of his right. We came across during the last class. You remember that. What exactly, how should that right under section 50 should be complied? Should the officer communicate that right to the accused, or is it or should that right be given to the accused only if the accuser requires the officer to do so? Then the Supreme Court here came up with the doctrine that is information should be, the accused should be made aware of this right. Inform the person to be searched of his right. Then search in the presence of that is, he should be searched in the presence of a GO or a magistrate acting under section 41(2) or section 42. Provisions of section 50 to that extent mandatory. Then section 52-57, arrest or seizure, steps to be taken by the officers. After arrest or seizure under section 41 to 44 are not mandatory. A mere non-compliance failure to strictly comply will not vitiate the prosecution. Then this is a full bench decision. State of Punjab versus Baldev Singh, 1999, 6 SEC 172. Kindly read this decision. Important decision. Section 5042, no prior information recovery. 50 not attracted where without prior information or during investigation contraband is recovered. Contraband is recovered. We have already explained that. Then section 50, recovery procedure of Narcotic Drugs and Psychotropic Substances Act should be followed when a search and seizure under the CRPC leads to the recovery of narcotic drug. That is, in the course of a search under 100 or 165, suppose there is a recovery of narcotic drug, then from that point onwards, the investigation should be in accordance with the provisions contained under the NDPS Act. Then, evidence collection. There should be exclusion of evidence of seizure of illicit articles taken in violation of provisions. Between 1994 and 1999, there was a quarrel between various high courts. And where high court said that suppose drug is recovered in violation of section 50. True, there is a violation of section 50, but drug is there. So only thing is that, so the mere fact that the police is able to establish in the trial by other evidence that the drug is seized from the accused, we will ignore the Magasar, but we will go through the other evidence and find the recovery, and on the basis of the recovery, we will find that the accused is guilty. Although there is infraction of section 50. That is why this decision went to the opposition. What happens to the recovery? There should be exclusion of evidence of seizure of illicit articles taken in violation of provision. That is, the recovery itself becomes inadmissible in law. That cannot be admitted as a piece of evidence. Vijay Singh Chandupa Jadeja, 2011 on SEC. Read this beautiful decision. 51. It would be imperative on the part of the empowered officer to apprise the person intended to be searched of his right to be searched before a gazetted officer or a magistrate. Insofar as the obligation of the authorized officer under subsection 1 of 50 of the NDPS Act is concerned, it is mandatory and requires a strict compliance. That is, it is in this decision that the Supreme Court came out with the doctrine of substantial compliance and strict compliance. Supreme Court said that the court, they should prove that it has to be literally complied. If there is no literal compliance with section 50, then the recovery itself becomes inadmissible in evidence. Failure to comply with the provision would render the recovery of the illicit article suspect and vitiate the conviction if the same is recorded only on the basis of the recovery of the illicit article from the person of the accused during search. The insertion of subsection 5, section 6 does not obligate the mandate of section 51 to inform the person to be searched of his right to be taken before a gazetted officer or a magistrate. Though it cannot be said that the protection or safeguard given to the suspects have been taken away completely, but certain flexibility in the procedural norms are adopted only to balance an urgent situation. Let us take a case. How do we cross-examine a 50 violation? How are we going to adopt this section 50 violation in the trial? If you don't have a well cross-examined case, you have nothing to argue in the appeal court. How do you do that? See, you take the magistrate, you take the session officer, and you go to the seizing officer and ask him, you are right to what the right Gazette officer Gazette officer. Therefore, the point of Gazette, I still remember in my first trial, in a murder case that happened in when the NSS President sir, he was my district judge. In the country, Bartha case. There was a child witness. I still remember when Prabharan Nair was the investigating officer. He was always sitting in the court. Then after the trial, there was a 27 recovery. After the trial, he called me and he said, sir, this is not the way you should question 27 recovery. 27 recovery, I have heard, I have seen P.V. Ayyappan, very famous criminal from Trichu, cross-examining the witness. That is, you take the witness bit by bit to the 27 recovery master. Then when was this information recorded? Who recorded this information? Was this information given to you or to the head constable or to the secretary? Who gave this information? Is there any contemporaneous recording of any other document other than this? Is it a part of the extract of the confession? If so, where is the 27 confession? In which part, which page of the case study this 27 confession recorded? And have you submitted the bail? Have you submitted this case study before the special judge, before the court session judge when the bail application came up for hearing? Are you aware that when the case study is submitted before the magistrate or the session judge during the bail or for other remand extension procedures, the magistrate will note the page number of the case diary concerned. Now, can you take the page number which is written by the session judge or the magistrate in this regard regarding your 27 Magasar? Which page is the 27 Magasar? Where is the triplicate copy? Where have you sent the triplicate copy? Is it endorsed by the circle inspector concerned? Like that series of questions where it will appear that the 27 recovery Magasar itself is a fabricated Magasar. He was just telling me. So therefore, like that, a 50 Magasar, a Magasar which speaks of the 50 Magasar will have to be gilded to the maximum. Otherwise, we will not be able to establish. Provided you are able to get the inter-se contradiction between witness to witness. PW1 to PW2, witness to witness. True. A contradiction of one witness cannot be used to contradict another witness. My contradiction is my contradiction. My contradiction is not your contradiction. I cannot use your statement to contradict me. True, that is there. That is a fundamental law. Even then I agree. But even then, if the case of the prosecution as narrated by one witness and the other witness regarding section 50 compliance goes in two different angles, one in the South Pole and another in the North Pole, then that is definitely a reason that will cause a dent in the prosecution case. Dent on the question of seizure. Okay. Then then state of Punjab versus Baljinder Singh. Sorry, it is Baljinder Singh. Between the 2019-10 SEC 473. Mandate of section 50 of the Act confined to personal search and not to search of a vehicle or container or premises. In a case where search of vehicle and recovery of contraband pursuant thereto having stood proved, merely because there was non-compliance of section 50 as far as personal search was concerned, no benefit can be extended so as to invalidate the effect of recovery from the search of the witness. Suppose the police, yesterday you went to Rumal, suppose the police comes up with a recovery Magasar where the recovery is not from the body, but then the Magasar will tell you that there is compliance of section 50. Why did you do that? It is not necessary. It is not. You should be able to bring up circumstances in your cross-examination to show that in order to introduce a public witness, an excise circle inspector or a joint commissioner of the excise, etc., as an independent, as a seemingly independent witness in the search proceedings, that is why this fabrication has taken place. Otherwise, no. That will create a, so therefore, the question that comes to my mind is the compliance of section 50, is it a question of law, is it a question of fact, or is it a mixed question of law and fact? It is clearly a mixed question of law and fact. Merely because the Magasar says that section 50 has been complied does not mean that section 50 has been literally complied, provided it is backed up by chief examination and not broken like a tissue of lies by the cross-examiner. If the cross-examiner is able to break it off, rip it open as a tissue of lies, then it goes. So, there, Baljinder Singh. Then we will go into 2016. This is Tufan Singh's case. Year 2020, Supreme Court of 5592. Same decision. Section 53. Scope of Section 53. Officers who are invested with power under Section 53 are police officers. Till then, the Supreme Court, till then we were saying that they were around police officers because Kumar versus Union of India. Justice Ahmed's decision. I still remember. Audible decision. When I was a narcotic prosecutor, then I stood up. Statement is the see, now the Supreme Court said they are police of the question. See, in Rajkumari Kariwal, taking cue from a decision in 1963, the Supreme Court said that only officers who are competent to file a report under section 173 are police officers. Since the officers, then the narcotic under officers other than police officers are not competent to file reports under section 173, they are not police officers. Therefore, their statement given under section 53A and under section 67 are admissible in evidence, and on the basis of that statement, he can be convicted. It appears in the Customs Act auto, Pavuni versus State of Kerala. It was argued by MNS. Kindly read that decision. Pavuni versus State of Kerala. I don't know. Excellent argument. Oh, MS Vanaka Nadam Salavan. Then Mohanlal versus Mohanlal's 2016 case is 6069. 6069 regarding the 52A disposal. Then section 60, liability for illicit drug substances, plants, articles, conveyance to confiscation. Mohammed Riyas versus State 2021 KHCAA 5821. Then procedure for making confiscations. Abdul Rahman Tawalapara's case, 2019 KHCAA 790. Justice made use of this. That decision said that it is the power to confiscation is with the court. Then section 64, it makes a deviation from the provisions contained in section 306 and section 307 of the Code of Criminal Procedure. That is the power to tender pardon is not with the court, but the power to tender pardon is with the central government. Suppose you are accused in a PC Act case, 3 of us are accused in a PC Act case, and I have a feeling that I am going to be convicted. Immediately I can instruct my lawyer to file an application to get myself come under section 307, Matam Booty. That cannot be done in an NDPS case. Jasbir Singh's case, AR 2001 Supreme Court 2734. Then section 66, presumption as to documents in certain cases. Now we saw section 35, we saw section 54, now we are seeing section 63, presumption of documents in certain cases. Muhammad Aslam Khan, AR 1996 Supreme Court 3033. Then come to section 67. Section 67 statement, whether it is admissible. Statements given to the officers, to the officers, investigating officers under the Act. Is it admissible? AR 2020, Tufan Singh's case. This is Nogunan Narima's decision. Supreme Court 5592. So, by this we wind up. Thank you. Have a fine day.
Thank you, sir. I invite our Vice President to propose the vote of thanks.
വളരെ ലെങ്തി ആയിട്ടുള്ള ഒരു സബ്ജക്റ്റ് ചുരുങ്ങിയ സമയം കൊണ്ട് വളരെ രസകരമായി ആദ്യ ക്ലാസ്സിൽ ഒരു ഇൻട്രഡക്ഷൻ ആയിരുന്നു. രണ്ടാമത്തെ ക്ലാസ്സിൽ സെക്ഷൻ വൈസ് ചെയ്യാനുള്ള ശ്രമം ലാസ്റ്റ് ഓടിച്ചിട്ടാണ് സാർ തീർത്തത്. നമുക്ക് വരുന്ന സമയങ്ങളിലും ഇതുപോലെയുള്ള ക്ലാസ്സുകൾ സംഘടിപ്പിച്ച് നമ്മുടെ കണ്ടിന്യൂ ലീഗൽ എഡ്യൂക്കേഷൻ്റെ ഭാഗമായിട്ട് ക്ലാസ്സുകൾ സംഘടിപ്പിക്കാം. നല്ല രസകരമായി നിരവധിയായ സെൻട്രൽ ഏജൻസികളുടെ പ്രോസിക്യൂട്ടറായുള്ള അനുഭവ പരിചയം നമ്മുടെ മുന്നിൽ പങ്കുവെച്ചുകൊണ്ട് രസകരമായി ഈ നർക്കോട്ടിക് ഡ്രഗ്സിൻ്റെ ക്ലാസ് എടുത്ത് നമുക്ക് ഈ കണ്ടിന്യൂ ലീഗൽ എഡ്യൂക്കേഷൻ്റെ ഈ സെഷൻ മനോഹരമായി ക്ലാസ് എടുത്ത ശാസ്താമംഗലം കുമാർ സാറിന് അസോസിയേഷൻ്റെ പേരിലുള്ള നന്ദി അറിയിക്കുന്നു. അതോടൊപ്പം ഈ ക്ലാസ്സിൽ രണ്ടാമത്തെ സെഷനിൽ നമ്മൾ ആളുകളുടെ കുറവുണ്ടായി ഞാൻ സാറിനോട് സൂചിപ്പിച്ചു. നമ്മൾ നേരത്തെ തന്നെ ലിങ്ക് പബ്ലിഷ് ചെയ്തു. അതുകൊണ്ട് പലരും ഓഫീസുകളിൽ മറ്റ് വരുന്നതാണ് ഇപ്പോൾ ക്ലാസ് അറ്റൻഡ് ചെയ്യുന്നത്. നമുക്ക് ഓൺലൈൻ വ്യൂവേഴ്സിന് നമുക്ക് കഴിഞ്ഞാൽ അറിയാം. കഴിഞ്ഞ പ്രാവശ്യക്കാലം നമ്പർ കൊടുത്തിട്ടുണ്ട്. നമ്മൾ ബാർ അസോസിയേഷനും എല്ലാം ഷെയർ ചെയ്തിട്ടുണ്ട്. അതുകൊണ്ട് നമുക്ക് ഇവിടെയുള്ള സെഷനിൽ അതുകൊണ്ടാണ് കുറച്ച് നമ്പർ കുറഞ്ഞത്. എന്തായാലും അങ്ങനെ ഓഫീസുകളിൽ ഇരുന്നും എൻലൈറ്റഡ് ആവാൻ കഴിഞ്ഞ അഭിഭാഷകർക്കും നിങ്ങൾക്കും എല്ലാം അസോസിയേഷൻ്റെ പേരിലുള്ള പ്രത്യേകം നന്ദി അറിയിക്കുന്നു.
Thank you all.